I'm Dr. Kalpana. In this lecture, we are going to discuss the concept of meeting in company law, its types, concept, and legal provisions. In this, we would be locating intricate legal framework governing company meetings in India as stipulated by Companies Act 2013. And we would try to understand fundamental concepts, various types of meetings, and their essential legal provisions, which provide a comprehensive understanding for company secretaries, legal professionals, and business students. So first, the concept, we need to understand what is the definition of meeting in company law. A meeting in company law refers to a formal gathering of the members or directors of a company to discuss and decide on issues related to business. These gatherings are crucial for corporate governance, ensuring that key decisions are made collectively and transparently. Section 96 to 122 of Companies Act governs provisions related to meetings of members, outlining the procedures, requirements, and responsibilities associated with convening and conducting such meetings. Adherence to these sections is paramount for validity of resolutions passed in company meetings. Now coming to what are the essential elements of a valid meeting, which is important to legitimize meetings in company law. So proper authority to call, who can convene a meeting? That is the first question. Only authorized individuals or bodies within the company, such as board of directors, have the power to convene a meeting, ensuring its legitimacy. There must be proper notice. A clear, adequate, and timely notice must be dispatched to all eligible attendees, specifying the date, time, place, and agenda of the meeting. These are the elements of that notice, which is called proper notice. Quorum, minimum attendance. A prescribed minimum number of attendees must be physically present for meeting to be validly constituted and for any business to be transacted. Chairperson. A designated chairperson must preside over the meeting to ensure orderly conduct, adherence to the rules, and efficient transaction of the business. Now coming to agenda. Agenda is one of the focal point of the notice and meeting. Without agenda, there is no purpose of calling the meeting. So a detailed list of matters to be discussed and decided upon must be provided in advance, allowing participants to prepare thoroughly. The last thing is in essential elements of meeting is minutes. Who are working professionals or doing some job must be knowing MOM, that is minutes of the meeting. Accurate and comprehensive minutes must be prepared and maintained, documenting all discussions, decisions, and resolutions passed during the meeting, which is an important document to produce whether a meeting took place, what was discussed in the meeting, and what was the purpose of the meeting, and after decision, what decision and resolutions were passed. Now coming to how many types of meetings are there in Companies Act. Section 96 to 122 deals with types of meeting. Holders, statutory meeting only for public companies, no longer required under Companies Act 2013. It has been omitted. Shareholders annual general meeting under Section 96. You must be knowing, whoever is dealing with the equity market as a shareholder, you must be receiving such emails of AGM, annual general meeting. Shareholders extraordinary general meeting, EGM, that is called EGM, that has been provided under Section 100. Shareholders class meetings, which has been provided in Section 48. Board of Directors meeting, that is called board meeting, which has been provided under Section 173. Board of Directors committee meeting that has been provided under Section 179, subclause 3. Others, meetings of creditor, debenture holders that can be notified by a national company law tribunal or concerned court. So, Company Act 2013 categorizes various meetings based on their purpose, attendees involved. This table provides a concise overview of different types of meetings a company may conduct alongside their relevant sections in the Act, highlighting the specific legal provision that govern each. Now coming to that is very important for all of us, annual journal meeting where all, even if you have bought a single share of any company, then that notification would be coming to you also by via email. What is the legal basis of AGM? So annual journal meeting is a cornerstone of corporate compliance in India, governed by Section 96 of Companies Act 2013. This section mandates the holding of an AGM to ensure regular interaction with company's management and its shareholders, fostering transparency and accountability. Applicability. An AGM is mandatory for all companies, irrespective of their size, nature, with specific exceptions. For example, one person company is an introduction, a new introduction by 2013 Act, who are exempted from holding an AGM due to their unique ownership structure, because it's a one-person company, so there is no board of directors, so with whom that meeting can be conducted. Additionally, private companies are generally not required to hold an AGM unless they operate as subsidiaries of public companies, in which case public companies' requirements extend to them. There are key requirements for holding an AGM, annual general meeting. Timeline. First AGM must be held within 9 months of the end of the financial year. I believe every listener knows about financial year start with 1st April and ends with 31st March. Subsequent AGM must be held within 6 months from the end of the financial year, with maximum time gap of 15 months between two consecutive AGM. That is the timeline, procedure, and mandate. Location and time. The AGM must be held at company's registered office or any other place within the same city, town, or village. It must take place during business hours 9 to 6 and not on a public holiday. Notice and quorum. A minimum of 21 clear days notice is required for an AGM. The quorum, as per Section 103, mandates 2 members for private company and 5, 15, or 30 members for public companies, depending upon their capital size. Business transacted at AGM. So other special businesses, any other special business requiring shareholder approval, provided proper notice is given. Appointment, reappointment of auditors, approving the appointment of or reappointment of statutory auditors for the company. Appointment, reappointment of directors, so electing or re-electing directors who are liable to retire by rotation. Declaration of dividend is also the part of that business of AGM. Approving the declaration of dividends recommended by the board of directors. Consideration of financial statements, reviewing and adopting the company's audited financial statements for past financial years. There are some case laws, which is a very important, National Dairy Development Board versus India Tourism Development Corporation, which comes from 1991. It is a legal precedent landmark case of National Dairy Development Board. Solidified the justice instance on critical role of annual general meetings in ensuring corporate transparency and accountability. This ruling underscored the importance of AGMs as primary forum of stakeholders, shareholders to exercise their oversight functions. Upholding importance court decision highlighted that AGMs are not merely procedural formalities but essential mechanisms for open communication between management and shareholders. It affirmed that through AGMs, companies demonstrate their commitment to good governance, allowing shareholders to scrutinize financial performance, question management decisions, and hold the board accountable for companies' affairs. Now, coming to the implications, this case continues to serve as significant reference point, reinforcing the legal expectations that companies must provide a robust platform for shareholders' engagement. It encourages the culture of accountability where management is expected to present a clear picture of companies' health and address shareholders' concerns effectively, thus contributing to the integrity of corporate practices in India. Extraordinary journal meeting, that is called EGM, urgent business. An EGM is convened to address urgent matters that cannot be deferred until the next scheduled annual general meeting. Beyond regular scope, these meetings typically deal with unforeseen circumstances or critical decisions that require immediate shareholder approval lying outside the ordinary course of business transacted at AGM. Legal provisions, Section 100 of Companies Act provides legal framework for convening EGM, outlining the procedures and conditions under which such meeting can be called. Now coming to the question, who can call an EGM? Board of Directors. So company's board of directors hold the primary authority to convene an EGM at any time they deem necessary, especially when urgent business arises that requires immediate shareholder resolution. This power is crucial for responsive corporate governance. Members, shareholders also possess the right to requisition an AGM. This can be done if members holding at least 1/10 of the paid-up capital for company request it. This provision empowers shareholders to ensure their voices are heard on critical matters. Tribunal, in exceptional circumstances such as cases of operation mismanagement within the company, National Company Law Tribunal may order EGM to be held. This power is stipulated under Section 98 of Companies Act as safeguard for minority shareholders and ensures the corporate fairness. Look at the comparison chart of AGM versus EGM frequency. AGM is annual general meeting. Definitely it has to be happen annually. EGM as required, depending upon circumstances, time frame within 6 months from financial year end. EGM can be conducted anytime, business, ordinary plus special. EGM can only be convened only on a special occasion, called by board, mandatory board, shareholder, tribunal. These three are stakeholders. Compulsory, yes, except OPC 1% company, it is compulsory. EGM is not compulsory because it is something which is called for urgent business. Now to conclude this lecture, company meetings are backbone of corporate governance, while AGM ensures accountability and regular oversight. EGM allows for urgent decision making. Compliance with statutory requirement ensures legitimacy, transparency, and shareholder democracy. With this, I would end here. Happy learning. Thank you so much.